Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Welcome to our First Friday event for the month of August. My name is Beth Mulcahy, and I am the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. We're so happy that you're here today joining us for our firm's live virtual First Friday event for the month of August. I've worked with HOAs and condominiums as their legal counsel for almost 28 years, and my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. First Fridays are a great time to get your questions on Arizona HOA and condo law answered at no charge. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer all questions between now and about 10 a.m. Just a quick friendly reminder, due to the large volume of questions that we receive, over 55 as of 8:45 a.m., this free opportunity is limited to one question per association. So if you plan on submitting a question live during this session, please indicate the name of your HOA or condo and your current role when you submit your question. We appreciate your understanding on this. Okay, let's get started with our questions. We have a lot of questions today. So first, I want to just do a quick mention of the 2024 legislation. Our firm has talked extensively about the new laws impacting HOAs and condos that will become effective on September 14th. If you missed class number 7 of our firm's 2024 virtual HOA Academy, I urge that you watch this video to get the 411 on the new laws. My team is sharing a link from our recent class queued up on the part to the presentation where I talk about the new laws. And just a reminder, we're going to be continuing to talk about the new legislation at our monthly neighborhood services class here in a couple of weeks on the third Tuesday of the month, just to answer any final questions you may have. And then we'll also follow up with any final questions that you may have at the First Fridays for September 2024, so that everybody feels really comfortable with the new laws when they go into effect on September 14th. Our firm is also working on finalizing the 2024 legislative update, which will be released this month. Let's get right into our questions. Our first question is from a committee member. Our documents state that the HOA shall be managed by a board of directors consisting of no less than 5 members. This has led to a situation where there were 7 and now down to 5, with 3 of the 5 terms expiring next year. It is hard to track terms and have any board member consistency, as terms are often not completed and the number of board members is fluid. Can we amend our documents to specify 5 only, but not record the amendments? Both the CCR and bylaws contain this language. Until other amendments are completed, the last significant update to our documents was in 1989. Okay, so great question. So it's on board member terms. It sounds like you could have 5 board members or more based upon the way that your documents are currently written. One really good way to have consistency on the terms is to make sure that the meeting minutes from regular board meetings and the annual meeting reflect whenever somebody is appointed and how long their term is. That always helps with the consistency. Also, having your management company or maybe your secretary keep a little chart showing who's on the board, when they were appointed or elected, and when their term is up, and then just keep that with the association's records. Okay, now to your question. Can we amend our documents to specify 5 only, but not record the amendments? So here's a couple of thoughts on this. Because both your CC&Rs and bylaws contain this no less than 5 members language, according to your question, you really would need to amend both of the documents to have this be effective, or actually the CC&Rs would be the most important one to amend, because the CC&Rs trump the bylaws and the CC&Rs must be recorded to be effective. And obviously CC&Rs usually also require a vote of the membership. So Hope that answers your question. We would recommend an amendment to your CC&Rs to change that language because just changing the bylaws alone isn't enough. Okay, question number 2 from an owner. My HOA has had over 2 years to fix the air conditioning in our gym pool room. The board members are gone in the summer and it cannot be used because it's too hot. They say they do not have the money, but I think they do have the money. We must keep putting money in reserves. I'm ready to sell because of this board, but would lose money by having a gym with no air. What can I do? I think that you need to document your concerns in writing to the board, number 1. Number 2, I think you should consider running for the board because it sounds like you have an interest in the community. You live there all year. And if you get on the inside on the board, maybe you'll have a better voice for them to hear you that, hey, this is not acceptable that we don't have air in our gym. And I think really anybody in Arizona knows it's unacceptable to not have air conditioning in a gym in the summertime. Some legal remedies that you would have, you could hire an attorney to write the board a letter telling them that they really need to do this or that you'll pursue your legal remedies against them. You could also file a complaint with the ADRE, the Arizona Department of Real Estate. There will be a $500 filing fee. You can find out information on how to do that by Googling HOA or condo and ADRE. And, I think those are just some good suggestions for you on how to proceed forward on this. Okay, next question is from a board member. A question has been raised as to whether email correspondence that does not meet any of the exclusionary conditions in ARS 33-1805 must be provided to owners who file an open records request under this statute. My research indicates that the descriptive term email reflects the process of transmitting information, and the determining factor would be the content of the email. As a general view, the content of the email would be evaluated in the same as any other document that may be mailed, handed out, or utilized in any manner by the association. I wanted to confirm that I had not missed any legal perspective prior to discussing with the board. Okay, so I believe the way that the direction of this question is going is, is email discoverable? Can homeowners ask for emails that are sent between board members or between the board members and the association's management company, etc.? I do think it's fair game to request copies of the emails from the board, and I do think the board has to comply with that request as long as it doesn't fall under one of the 5 exclusions that records can be withheld from discovery. And some of the examples would be like advice from your attorney. You can't have an email where I'd be giving advice to the board in an email as their attorney. Also, you wouldn't be able to have any emails regarding any pending litigation. Those would be some easy examples. Okay, next question, number 4. We have a member who's been trying to get a copy of adjacent members' building plans in an attempt to influence the placement and style of the new home they have submitted to the architectural committee for approval. They have made repeated requests for a copy of them to the building member, the ARC, and the local town permit department that all 3 entities have denied. The ARC has created a building requirements checklist to help new builders and their contractors see and follow in a single document all the HOA's building requirements that are contained within the CC&Rs and amendments. The requesting member has stated that the ARC checklist needs to be shared as it falls under the following Arizona statute, 33-1805, which is the records request statute. The ARC does not consider the checklist to be an official HOA document that needs to be made accessible by a member request under this statute, because it doesn't have anything to do with the financial status of the association and or expenses, operations related to the gate keypad infrastructure or street that the association is required to maintain for our members. We only have an entry gate and a street that the association maintains. There are no association buildings. Only structures are the HOA member homes. Are we required to share the ARC checklist with the requesting member? Short answer on that would be yes. I do think it's a book and record of the association. I do think it relates to the association, and I think you should be sharing that with your homeowner. Okay, next question from a board member. Can an HOA committee be one person who is a board member or a 2-board member committee? So we have a great cheat sheet on this. One other thing I wanted to mention on the last question, we shared with you a cheat sheet on community association records and documents that might be helpful on what needs to be disclosed and doesn't need to be disclosed to members. Okay, next question. Can an HOA committee be a one person who is a board member or a two board member committee? We have a great cheat sheet on association committee basics that I would recommend that you take a peek at. Short answer would be, it depends on what your CC&Rs or bylaws indicate on the HOA committee. Sometimes the number of committee members is specific in the documents, and if that's the case, you would need to follow what the documents say. Most of the time, the documents are not specific on it, and in that case, having a one-person board member committee is fine, and that's perfectly legal. You also could have a two board member committee. Remember, anytime you have a quorum of the board on a committee, the meeting needs to be noticed as a board meeting, even though it's a committee meeting. Okay, next question, number 6. Can or should this statement be included in our rules and regs? All vehicles parked in our association must have current license plates and be operable. Can this be included in your rules and regs? I mean, I'd have to see how broad your rulemaking authority is in your CC&Rs, but most likely yes. Should it be included? I mean, it's really at the discretion of the board. If you have issues with owners having vehicles in the association that are unlicensed and maybe have wheels off and are inoperable, then this is maybe something that you should consider, putting in either your rules or in your CC&Rs. Again, look at how broad the rulemaking authority is before you would ever pass a rule like this. And you may want to define specifically what operable means and what current license plates mean. So it would have to be current license plates that are registered for that year, and then define what operable is. Our firm would be happy to help you with that if you have any questions or you want us to take a peek at your rulemaking authority. Okay, question number 7. The new law regarding community street regulation requires an in-person meeting with the community prior to voting. Can that meeting be part of an annual meeting? So we have a great legislative update on that new law that went into effect in 2023. So take a look at that for the 411 on that law applies to planned communities and the vote that's needed to continue regulating your street parking. Yes, absolutely. That meeting, that vote, in-person vote can be part of an annual meeting. It just needs to be a meeting of the membership, and that could be an annual meeting or another meeting of the membership. The next question, number 8. Our HOA is adding security cameras throughout the community. Is it legal for the board members to have footage and be able to view on their personal devices? Recourse for owners. So we have a great blog that we wrote a couple years ago on security cameras, which we are going to be sharing with you. So take a quick peek at that. I mean, I think it is not unusual, just so you know, that board members would have access to that security footage. It depends. I mean, if you have a management company, usually they're the ones that are going to have the access to view it on their personal devices. But sometimes if you're self-managed, the board members have that access. I know for my community, I'm on my board, and I chose not to just because I don't, that's just not something that I have time to do. But the manager has the access to the footage, the video footage, and she has a big screen in her office where she's able to watch it throughout the day. But I do think it sounds to me like maybe you think that this might be an invasion of privacy. As long as the cameras are pointed towards the common areas and not towards any individual units, this probably is something that your board members can do. Okay, next question, number 9. Our community is a 252 units, 36 units per a 3-story building. If water leaks, for example, from the second floor into the first floor and the cause is a broken dishwasher, does the association have to pay for the repairs? It really depends. We always look at these insurance issues on a case-by-case basis. We have to look at what your CC&R state as well. I will say in most condominiums, the association's insurance is the primary insurance, which means that when there's a claim that's made, typically the association's insurance pays out first. The issue of the deductible comes into play, and if the water leak from the broken dishwasher is the fault of the upper level unit owner, they may be required to have to pay that deductible. So insurance questions are kind of tricky, but that would be just my quick general answer for you. Without seeing your documents and without knowing more about the extent of the damage, I mean, you also need to consider how serious is the damage. If it's less than deductible, then Typically, the owner above would just pay the owner below to take care of whatever the paint and any water damage, bubbling in the ceiling, etc. Again, we got to look at that on a case-by-case basis. Okay, next question, number 10. From a board member, we have a 5-person board of directors. One board member, who is currently vice president, has serious health issues, and his ability to be an effective and responsible director is being severely compromised. He refuses to step down from the board despite being asked to do so. How does a board of directors or homeowners in our HOA remove a director that has serious health issues but refuses to step down? We are well aware of what our bylaws say about removal of a board member. Okay, there's a process under Arizona law for removing directors, and we have it listed in our top 10 cheat sheet. We're sharing that with you right now. There's a whole process you follow. That process trumps your documents, so you need to be aware of that. This is kind of a sensitive situation. If you have a director that is ill, I don't know if this is a long-term illness where the potential is that this person is going to pass away, or if this is just like a 6-month, 3-month situation. I think the best thing that you could do is open the lines of communication with the director at a board meeting. Hopefully they're still coming to the board meetings, and find out, express sympathy and empathy for their situation and find out what their thinking is on this. Do you think you want to stay on because you think that you're going to be able to come back when you're feeling better? Would it be possible that you take a leave of absence and we appoint somebody in your place during the leave of absence? Doing a removal meeting to remove a director who has severe health problems, I think that's not going to politically go over well with your community. Maybe I'm wrong, but that's my first instinct on it. So I think what I would do first is open lines of communication, in as polite a way as possible, express concerns that maybe they aren't able to fulfill their fiduciary duties to the corporation right now because of their illness, and maybe give them the option that when they're feeling better, the person that's appointed will resign and they can be reappointed. Okay, question number 11 is from a board member. Is it legal for a board member to use their out-of-state business email for a signature? This includes a privacy statement and a notice that emails cannot be forwarded without permission for all HOA and vendor communications. The board member claims the HOA lawyer approved this, but we are unsure if the lawyer reviewed the full details or provided a written opinion. It's not illegal. Let's put it like that. It's probably not best practices to do this. So I would recommend that they set up a separate email, especially because of the sensitive language that's in the email. Number 12, from a board member, can a homeowner with delinquent assessments run for the board of directors? Our CC&Rs state that a member cannot vote if they are delinquent, but they can still run for a position on the board. So yes, this is kind of a weird concept, but a homeowner who's delinquent can run for the board and be a board member and vote as a board member, even though they are delinquent. Now, obviously, this is a very bad example for a board member to be delinquent, and we would never recommend that. I would talk to the board member individually if we ever had a situation like that, tell them to get their assessments current or quit. But it is a weird kind of loophole in the law. So the only exception to that would be if the documents for the association said that there was a requirement that in order to run for the board or to serve as a board member, that you have to be current in the payment of all assessments and other fees that may be owed to the association. In that case, then that person would not be able to run or serve on the board. Question 13 from a board member. Are there specific limitations on the use of a city designated right-of-way in a community, such as restrictions due to utilities, cable, or construction? If not, should the community establish an easement deed or written agreement with the city to address other uses like the placement of political signs? So great question. Typically, all of these easements are already on your plat map for your association. So I would recommend that you take a look at the plat map to see what specific language is on there. I also would just check in with your city, town, or municipality to find out what their position is on political signs on city designated right-of-ways. Next question, number 14 from a board member. We have a past board member that has a cease and desist order. With elections coming up, can we prevent them from running or being on the board? So although it is odd that, maybe you have a cease and desist order, and I don't know if this is a formal one that was done by a court, or maybe if this is just one that your board put in place, meaning don't contact us. I'm assuming that's what you mean by the cease and desist order. I do not think that you can prevent them from running for or being on the board, even though you may have sent them a cease and desist letter. Number 15, does HB 2698 allow HOAs to foreclose on a home? If so, what are the circumstances? So I think maybe you meant House Bill 2648, which is the new law that's going to be going into effect in mid-September. Really, it doesn't necessarily change this for us to be able to foreclose. There are some caveats to that, but basically we can only foreclose, when an owner is delinquent in the payment of assessments to the association, and they need to be delinquent 1 year in the payment of assessments, or they must owe $1,200 in assessments only. So that's the threshold. That hasn't changed with the new legislation. What's changed a little bit is what we can put into a lien, a foreclosure lien. We can no longer automatically add in legal fees. Is probably the biggest distinction from the statute this year. And so just a short answer to your question, we still can foreclose on the home just like we always have been able to. We just have to meet that benchmark. Now, what we can put in the foreclosure lien to foreclose on has changed a little bit with the new law. I'd encourage you to take a quick look at our seminar that we did for our class number 7 for our neighborhood services class. We shared the link already earlier today. And I can talk through with you through that class, the specifics of that law. Okay, next question, number 16. Here's a clear version of the question. We are considering changing management companies for accounting services only. We've been informed that there will be a $500 fee for on- and offboarding transition coordination, which is listed on our annual payment schedule. The new vendor mentioned that this fee is not standard in our industry. As a community of 12 units, we find this fee excessive. Is there any way to challenge or negotiate this fee? Okay, so it looks like you're changing management companies only to do accounting. They're charging you $500 for an onboarding fee, at the beginning and the end of your relationship. I'm not sure if that's $500 on both sides or just $500 and it covers entry and departure. Sure, of course, you can negotiate this with them. You are a very small association, 12 units. I do feel like that's kind of high. And it just depends. We're seeing more and more of these onboarding fees. So management company charging these onboarding fees. So, just in a very polite way, I would just say, hey, we're a very small community. Could we negotiate this and maybe offer $200 or something like that? Or for 12 units, you could say something like $20 a unit or something, to onboard. And that seems like a reasonable alternative. We have 2 cheat sheets on management companies that you may want to take a look at, how HOAs can make a clean break from the management company, and then also how to select a management company that might be helpful for you as you navigate the new management company hiring process. Okay, question number 17. We have problems with vandalism from teenagers in common areas where cameras are present. Often we cannot identify them and have considered emailing their photo to the residents or posting them on our website for help. We've received differing opinions as to whether this is legal since they are minors. Can you point me to a governing statute that details this? I guess just generally speaking, my office did some quick research on this, and it's not illegal to capture or share images of people in public spaces where there is no reasonable expectation of privacy. However, it's really not something that we're recommending, that you're sending out a blast email saying, do you know who this person is? We could have potential issues with sharing minors' videos, pictures of minors in the videos, and a potential defamation claim if somebody was misidentified. I think the way to handle it would be to show it to the board, see if they know who that person is, provide the video to the police, check to see who's swiping their cards to get into the pool. Hopefully you have an electronic access system, so you may have a listing of how many swipes there have been, and maybe you could cross-check with those people to see if they're, if any of them are aware of who this person might be in the videos around that same time period. We also have a great cheat sheet on preventing crime and limiting liability, which gives you some suggestions on how to best manage any crime that's occurring in your community. Okay, question number 18 from a board member. Please help us clarify the legally required accommodations an HOA must make for service dogs and ESAs in common areas such as pools and barbecue areas. Being privately owned, are there any exemptions? And is there a distinction or limits between access rights for emotional support animals versus licensed service dogs? A couple things we want to share with you. We have a cheat sheet on federal laws, which talks about the requirements for associations to make reasonable accommodations for emotional support pets. We also have, and service dogs as well. We also are sharing with you an article that CAI, Community Associations Institute, the national think tank for associations, put out on fraudulent emotional support animal requests, how to protect your association. So associations are required to make a reasonable accommodation for service dogs and emotional support animals. How far that extends is something that I think we have to look at each thing on a case-by-case basis. Service dogs, you could never make them put a leash on the pet if they're in the common areas or in the pool, because service dogs typically never have leashes. Emotional support pets, that's a little different situation. You could require a leash on that. In my opinion, neither of the animals should be allowed to be swimming in the pool. We have, like in my association where I live, service dogs and emotional support pets are allowed in the pool area, as long as they're not barking or dangerous to other residents, but they're not allowed to be in the pool. All really good questions. There aren't any specific answers under the law on it. So I would recommend that you reach out to us if you have a specific circumstance with an emotional support pet or service dog, which is creating an issue in your community. You want to be very careful on this because the Fair Housing Act is something that we don't want to violate. And we have to be very careful not to discriminate with any owners who have disabilities that would fall under the Fair Housing Act. Okay, question number 19. A homeowner is over $1,000 delinquent in dues. After next week's board meeting, I will be contacting you for a demand letter and legal action. Must I accept partial payments toward this delinquency? So yes, I think anytime an owner wants to make a payment on the delinquency, I would accept it as long as it doesn't have a restrictive endorsement. Remember also, before you would ever turn over a delinquency to the association's attorney, you must send the certified mail notice pursuant to Arizona Revised Statutes 33-1807K and Arizona Revised Statutes 33-1256K. Question number 20. Who has the final authorization for each board meeting agenda, the community manager or the president? We have a great cheat sheet on association board meetings that I would encourage you to take a peek at. My opinion on this, there is really no right answer on this, but, my opinion is that the president does, because the manager works for the president. And if there's a power play going on where the manager is saying that you can't have certain things on the agenda, that is improper. Okay, don't forget who works for who. The management company works for the board. Obviously we're a team. I work for the board as well. We're a team and, we have to work together, but ultimately the association's board is making the final decisions on things. Number 21, from an owner, can the HOA delay or prevent the sale of a home if said home has compliance violations? So really good question. So you cannot delay or prevent somebody selling their house. Okay, that would be like an intentional interference with the contractual agreement, and I would advise against that because you're going to get involved in a lawsuit. What you can do is you can put on the disclosure statement that the association gives the buyer, a description of any violations that are on that lot, and let the buyer know that, hey, these violations exist. They either need to be taken care of at the time of the sale, or you're going to have to deal with them when you become the owner. Question number 22, from a manager. If the association's documents do not explicitly prohibit homeowners who are not in good standing from serving as board members, would addressing this issue require an amendment to the CC&Rs or bylaws, or could the board simply pass a resolution or establish a new code of conduct to facilitate the removal of a board member without needing a vote of the community? Okay, so lots of issues in this question. So, if your documents don't prohibit owners who are in bad standing, so like if they owe money or they have violations from serving on the board, the association can't go around that by passing a resolution or a new code of conduct. this really would need to be something that was written into your CC&Rs and voted, or your bylaws and voted on by the membership. Next question, number 23. Does association law require that insurance for condo associations include additions or improvements to buildings? Specifically, screened-in porches that were converted to living spaces years ago. The condo footprints are the same as originals with screened porches. If an insurance company claimed that we opted out of such coverage, does the law require a certain type of language to be included in the policy? The declarations page just states buildings and the amount of coverage, and we can find nothing in the policy for coverage for additions or improvements. This issue came up when members tried to pair their inside condo coverage with the association's outside condos coverage. This is a really interesting question. I think what I'd like to look at is I honestly don't know the answer specifically without looking carefully at the Condominium Act about whether insurance for condo associations includes additions or improvements to buildings. I'm assuming it would, because this type of thing happens frequently. You're making improvements to the condo. It depends on how the policy is worded, though, probably. What I would do is, if I were analyzing this issue as your attorney, I would look at, what do your documents state? I would look at the plat. I would, the porches probably, I don't know if these are like porches that are attached to the building or if it's more just like a concrete slab. I'd also look at how unit is defined. I think there can be some pushback on this with the insurance company. I'd probably have a phone call with the insurance agent to talk it through. Question number 24 from a board member. Can the association charge a transfer fee and a capital improvement fee for the sale of a property if the CC&Rs do not mention this? Is there a maximum? So we have a great cheat sheet on disclosure fees and transfer fees, which I would encourage you to take a look at. So you cannot charge a transfer fee or a capital improvement fee for the sale of a property unless it's written into your CC&Rs, and that would require a vote of the membership. Our cheat sheet on this really extensively analyzes that, so I encourage you to take a look at that. Question number 25. If CC&Rs have a rental restriction of not less than 30 days and the board wants to change it to 90 days, is this something that can be done with a 2/3 vote of the owners, or could there be a higher threshold required for approval of this change, given that owners may not have anticipated this kind of change in the future when they bought their unit? So great question. This brings up issues on the Camelback case in Arizona, which talks about, was decided several years ago by the Supreme Court of Arizona. And it says, that amendments need 100% approval if they are not foreseeable or if they are not reasonable. This is kind of a tough call, because going from 30 days to 90 days, is it foreseeable? Is it something that an owner in your community is going to challenge? I'm assuming that you have an issue with this in your community right now, and that's prompting you to make that change. Look at our cheat sheet on amending association documents and implementing rental restrictions. I think we have some good tips in there on how to navigate rental restrictions. If I were advising, an association on this, some things that I would be asking, well, first I would bring up the Camelback case and say, okay, this is a little problematic, because somebody could say that, hey, I bought my property with the expectation that I was going to be able to rent for, not less than 30 days. I was able to rent for 45 days or whatever. And now you're taking that away by changing it to 90 days. And, they probably would have a decent argument to that under the Camelback case. One creative way, so back it up a little bit. What I would do is I'd want to know about the demographics in your association. Is anyone going to challenge this? Have you talked about this with your members? If no one is going to challenge this and everybody is generally in favor of it, then I think you may have to balance the risk of being challenged under Camelback and, going ahead and doing the amendment after getting the requisite vote of the members. If you think somebody will challenge this, what you may want to do is grandfather all existing owners and say that anybody who purchases after the date the CC&R amendment is recorded would be subject to the 90 days. And that would be a way to phase this in for new owners. You would not have the challenge from anybody who might be opposed to this within your community. Okay, next question, number 26. The HOA put in a false claim with the insurance company, and the insurance company paid out a much smaller amount. I know the claim was false, and the insurance then went up 400%. All members are paying for false claims. Should I turn them in for fraud? What are the repercussions? The insurance company tried to get me to pay debt. I sent them proper documents, and they removed my name. The president tried to blame me for misappropriation of funds under oath. I was used, and now members are paying for this fraud. And interestingly, this question is from a manager. Okay, this is a tricky situation. So I don't know much about the insurance claim, right? I don't know why it was false. It's hard for me to comment on it. If the insurance company paid out a claim, in my experience, the insurance company usually does due diligence and investigates the claim. Maybe the association pulled one over on the insurance company. I'd be surprised, though, because that insurance companies are very diligent before they pay out any money. It sounds like they paid out a much smaller amount. You don't define that, so I don't know how much that is. Your claim that the insurance went up 400%. I'm not sure that paying out a much smaller amount, again, I don't know how much that is on one claim, caused the insurance to go up, by 400%. So it's hard for me to comment on that. Were there a lot of other claims in your association in the past few years? I do know that insurance rates in general have gone up for every association, including my association. I guess your claim that all members are paying for false claims, should I turn them in for fraud? I really don't have enough facts to even think about advising you on that. So I'm not going to, because I don't know enough of the facts to even comment on this. I'm not sure why the insurance company tried to get you as a manager to pay the debt. It sounds like maybe something happened here where the insurance company came back and wanted the money back from the association, and you gave them documents, and then they removed your name from the documents, and then the president tried to blame you for misappropriation of funds. I think it's best to move on, would be my advice to you. If you feel that you have a claim against the association in some way, you should get your own legal counsel to evaluate that claim. Okay, number 27 from a board member. During the election campaign period for a board election, should sitting board members remain publicly neutral as to support for any particular candidate, or is it ethically appropriate for an individual board member or the board collectively to publicly endorse and campaign for a particular candidate? Should this issue be addressed in the board's code of conduct? This is from a board. I guess there really is no right answer on this. More likely than not, sitting board members don't get overly involved in the campaign for new board members, meaning they're not endorsing and they're not getting in the weeds on it. There's typically a candidate night and they let the homeowners decide. Now, that being said, I will say I have seen this before where the board really wants a certain candidate or really doesn't want another candidate who's running for the board, and they become more vocal about who they prefer to have serve on the board. Although that's not my preferred way to handle things, my feeling is that they have the right to do that as long as they are fair and impartial. But it's not my suggested course of action. And if they are doing that, they really need to recuse themselves from any part of the ballot counting so that there's no question of any impropriety that's on the part of the board. Could this issue be addressed in the board's code of conduct? Absolutely. That this is something that we ask board members to not do. If your board votes to do that, that's something that you could definitely include in your board's code of conduct. Okay, we're on question number 28, and we have 51 questions as of right now. How should we handle a property manager who talks over board members during HOA meetings? That's not a good situation. I think the best way to handle that would be for the board president to have a conversation with the manager and just pleasantly and politely just talk it through and say that, hey, we've noticed that this has been happening and we would prefer that we don't handle our meetings in this way. We let the board members be able to speak without having somebody talking over them. And so we're asking that you please not do this going forward and see what happens. If that doesn't work, then you may need to go to the property manager supervisor and talk about it with that person. Question 29. Since smoking marijuana in private spaces is legal in Arizona, what, if anything, can an HOA do about homeowners who are smoking marijuana in their backyards? And especially when the backyard adjoins association common areas such as pool facilities. This is a difficult question. We have the same question in condos, often where the vents are, the smell is going from unit to unit via the vents. A couple things, marijuana is legalized in Arizona and owners are allowed to smoke it in their private spaces. I guess the question that I would have is that backyard actually their property? Like, are they smoking it within the confines of their unit or their lot? If so, that's probably okay. If they're creating a nuisance, that is a different issue, meaning that the smoke is causing others to feel uncomfortable or not be able to enjoy their property or the common area pool. Then I think what I would do is write them a letter stating that this has come to our attention. We've had complaints. This is considered a nuisance under the terms of our documents or CC&Rs. Most documents have that provision in there, and ask them to please not smoke in this area. Question number 30. Our HOA is in a high wildfire risk area, and the local fire chief has recommended against using natural wood siding. Local insurance brokers are unable to offer homeowner policies through preferred carriers, and new home sales are being impacted due to the difficulty in obtaining insurance. Our CC&Rs require solid wood siding for about 20% of our homes, but allow for variances. Can we offer a temporary variance allowing homeowners to use more fire-resistant building materials due to the current wildfire concerns and insurance challenges? Yes, what I would recommend is ask the fire chief to put that in writing, that they're recommending against using the natural wood siding. I also would have your insurance broker weigh in on this in writing if they're willing to do that. I would consider amending your CC&Rs. I would just notify your owners of this, situation and include the letter from the local fire chief and the insurance company, if you have it, explaining the board's rationale for this. And just to tidy up the documents, I really would do an amendment to your CC&Rs to take that provision out. But in the meantime, I think having good communication with your owners, this is a life, health, and safety risk, and I think you are, would be well within your rights to do that. Also, because you have that variance language in your documents. I haven't seen it, but you indicate that it does allow the board to give variances. Number 31, our small HOA has an owner who constructed a shed in violation of our HOA documents, although it complies with city regulations. The owner is rarely around and has legal representation. Given that litigation is unaffordable to us, what options do we have to address this violation? Okay, so this is a good question because this type of issue comes up frequently. An owner has a violation that violates the association's CC&Rs, but it doesn't violate like any local or city ordinances. It's still a violation of our documents. What I would recommend is I would write a letter to the owner about the violation. I don't know how long the shed's been there. Hope it hasn't been there for more than 3 years, because if it has been, it may be difficult to enforce. But I would write a letter to the owner, a violation letter, and I would indicate in the letter that if you don't comply with our documents, we have a number of different legal remedies that we will take against you. We can file a complaint with the Arizona Department of Real Estate, and for $500, have a administrative law judge make a ruling on whether or not this is a violation. So that would be like a real cost-efficient way to do that. We can file a lawsuit in Superior Court, and get an injunction compelling you to remove it. Now, that's probably not going to happen for you because you said litigation is unaffordable for us. These are all different remedies you have. Obviously, the cheapest remedy, free remedy, would be pick up the phone and try to talk with the owner about this. Try to get some FaceTime, get a meeting, talk it through with the owner. Okay, next question, number 32, from a board member. The association is in the process of having the annual tree trimming done. However, we have had a few homeowners trim association trees that have grown over the community wall into their yard. Some trees have been damaged and will need to be removed. If the homeowner denies that he damaged the trees, what do you recommend that the association do? At this point, the association is absorbing the costs of the removal of the damaged trees. Good question. I mean, under Arizona law, owners do have a right to trim the trees back to the property line if it's extending into their property line. It's often very difficult to prove that trimming a tree back to the property line is, in fact, cause the tree to die. And you'd have to have an arborist testify to that and put, that in writing. But I think that's going to be really hard to prove. Oftentimes, what we have seen is that maybe the neighbor poisons the tree, and that's what makes the tree die. And sometimes you can't. It's hard to prove that too. There's actually a national case right now that kind of caught my eye. I think it's in Maine, where one neighbor, was trying to protect their view, and they poisoned a bunch of trees of their neighbor directly adjacent to them to improve their view. And it's getting a lot of national attention right now because not only did it kill a bunch of trees, but it also contaminated the land and potentially the water adjacent to these homes. So it's a big, big issue. And these are very expensive homes where this happens. So, I don't know all the facts on this, but have an arborist come out, give you some advice on it. If you can prove that potentially they did do this, and that their trimming did cause the damage, you may want to reach out to them to, see if they will, pay to remove the tree. They might actually be really willing to do that because they probably don't like the tree dropping, things on their property. And if it's half dead, they probably don't like the way it looks. So hopefully you can resolve that. If not, I'm not sure you have to weigh how much is this going to cost to fight this. Get an arborist versus how much is it going to cost just to stump the tree and be done with it. So all good practical considerations that you should take into consideration. Okay, question 33, newly passed House Bill 2648, Article 33-1202 definitions. New paragraph number 10, common expense lien. Do you understand an HOA cannot collect legal fees and costs unless a lawsuit is filed and are awarded by a court? If yes, the legal fees and costs then become a common expense and the homeowner has no legal obligation to reimburse the HOA. Okay, so you don't have that exactly right. So yes, the new law, which is going to go into effect in mid-September, I encourage you to listen to our class that we taught last month. It's on our website under our helpful videos section, class number 7. We also shared the video with you earlier today during this class. So, here's how it works. Under the new law, the HOA cannot lien for legal fees. We used to be able to lien for legal fees, but as of mid-September, when this new law goes into effect, we cannot put on the association's assessment lien the legal fees. What we can do is we can include let's give an example. Let's say that, we have the owner owes $3,000 in assessments and we maybe have incurred $1,200 in legal fees. So how this works is that the association will record a lien for the things that we can lien for, which is going to be like the unpaid assessments. We can't lien now for the attorney's fees. When we go to file the foreclosure lawsuit against the owner, we make a foreclosure count claim for the unpaid assessments, and then we make a claim for a personal judgment for the unpaid attorney's fees. When we get that judgment, we can take the foreclosure lien to the sheriff and have the property sold, for the assessments that are past due. For the legal fees, we can record that judgment with the Maricopa County Recorder's Office or whatever recorder's office that your property is located in, and it becomes a judgment lien, which is like a personal judgment that we can enforce against the owner. And we can collect that by garnishment of their wages, their bank account, garnishment of rent if they're renting any properties in Arizona. So there are ways to collect on it, but I'm not going to lie to you, this is more challenging for us to get our attorney's fees now with this new legislation, in that it's not just automatically part of the lien, and it's just not going to be automatically paid at the sheriff's sale. We have to, take that judgment. It's a personal judgment. We have to record it with the recorder's office. It becomes a judgment lien. We get paid either by garnishment or when they sell their property. Okay, next question, 34. Can a motion be made at an annual meeting to increase the board member positions in case there are contested positions? So example, increase from 3 to 4 or 5. It really just depends. If your documents have some fluidity on how many board members you can have, like maybe it says you have to have a minimum of 5, but not more than 9. I've seen this happen at annual meetings when you have, bylaws that aren't so specific or CCNRs that aren't so specific, meaning, hey, we've got 5 people or 6 people interested in being on the board. And, we've traditionally only had 5, but now we want to have 6 to get some extra help. And our documents allow for it, we're going to just bring that extra person on board. Where you wouldn't be able to do this is if your documents were very specific in that you are only allowed to have 3 directors and you couldn't just, increase it contrary to what you'd say. Now, what you could do is put that extra person on a committee in that situation. Okay, next question, 35. How do you handle inter-board conflict and bullying? Boy, this is a big question right now, big problem too in our industry. So what do you do when your board's dysfunctional? We have a great blog article on this that we're sharing with you. We have a cheat sheet on how to effectively deal with a bully in an association. We also have a cheat sheet on dealing with difficult people that I think would be very helpful. One way that the fastest way to handle, after you take a look at these publications, and all of these can be found on our website at mulcahylawfirm.com. But the best way to handle interboard conflict and bullying is to have a boot camp where I come in and I talk to your board. And we talk through the issues. We spend about an hour and a half to 2 hours. Maybe it's on Zoom, maybe it's in person. And we get all the issues on the table. We talk about where everybody's coming from and where we are going forward so that we can be a high functioning community. Now, if a bully on the board, sometimes if they don't improve after that meeting, maybe you need to do a removal petition to get rid of them. I can better size up the situation once I know more facts. Like, okay, I think this person can be turned around, especially after I meet with them and the entire board to try to talk through the issues. So we do have a charge for our boot camp. I encourage you to reach out to our firm to find out more information about this. Our email is info@mulcahylawfirm.com, and we can send you our little packet as to how we structure the boot camp and get you set up for one if you'd like that. Okay, question 36 from a board member. We are a self-managed association and are having difficulty getting people to serve on the board. Can we offer an incentive such as a discount of the yearly dues? So good question. In my opinion, no, you cannot do that. The only exception to that would be is if it's in your that board members are entitled to receive compensation for their service. I don't know any associations that are currently doing this. It would be highly unusual. And I'm really not in favor of it either. So I think the pivot is part of the Nonprofit Corporation Act that allows, you to have that in your, if you want to do that, but I don't think it's a good idea. Maybe what you need to do is take a look at our cheat sheet. I think our annual meeting cheat sheet has suggestions on how to get board members. Also, we typically will send a letter. This is a very good strategy. If you can't find board members, our firm sends a letter to all the homeowners, letting them know that, hey, if we can't get board members, we're going to have to go into a receivership and this is going to cost our association a lot of money and your dues are going to need to be increased. And typically that gets some people out of the woodwork to serve on the board. Question 37 from a board member. What is your opinion in regards to an HOA having to pay an interpreter for meetings when you have a deaf homeowner? Ooh, that's a really good question. I haven't had that one before. Okay, let's get my bar exam skills out and analyze it. So, okay, if you have a deaf homeowner, obviously this person has a disability under the Fair Housing Act. And the issue is, do we have to make a reasonable accommodation to, have this person be able to listen in on the meetings? I guess some good thoughts on this would be, I don't think, I also get this question on, do we have to translate documents or in a different language? That's not necessarily a fair housing issue, but I do get that question from time to time. If we have a high population of Russian residents or something like that, do we have to translate our documents into Russian? No. In this case, no. But I think you could do some positive things that would be helpful. What I would recommend is that I would recommend that your association have a Zoom component in your board meeting and have the closed captioning on Zoom, which would allow the words, everything that's being said is going to be on the screen. And I think that is a really good solution here that honestly we didn't have before the pandemic. So I would encourage you to do that. Zoom is free for 45 minutes at least, and it's very low cost if you're going to get a package. And I think you really should consider doing that to be, kind and fair to your resident who is deaf. Okay, question number 38. Our management company is requesting the board sign a resolution of the board relating to discrimination pursuant to ARS 33-1804, something to do with U.S. housing and urban development. The board is questioning it if we have to sign this. Honestly, I don't know what specifically they're asking you to sign. If you'd send it to me, I can take a look at it. I don't know if it's pertaining to the new legislation that starting September 15th, we're able to automatically amend the CC&Rs, the board is, to remove any discriminatory language. I don't know if it's related to that or if there's something, that they're making you sign saying that the board won't discriminate. Unless I hear more, I really don't know what that resolution's saying. I would say I haven't heard much about this from anybody else in the communities that I represent. Over 1,000 associations have not had this question yet. And I don't think the management company can make you sign anything. So, get your legal counsel involved. Make sure it's independent legal counsel and not legal counsel for the management company, because you want somebody who has your best interest at heart when they're giving you advice on this. Okay, question number 39. What restrictions should HOA committees have regarding the sharing of written documents, plans, or budgets when residents are attending committee meetings? Okay, so this is from a board member. So I'm not really sure what restrictions. So, I'm all about transparency for associations. So, if an owner wants to see documents that are documents for the association or for the committee, proposed plans or proposed budgets, I think that's fair game for the owners to request them under a records request. Okay, and then we can determine once we get that records request whether any of those documents that they're requested are, something that we, under the law, can prohibit them from having. Question 40 from a board. Now that it sounds like HOAs can no longer automatically charge homeowners legal fees for collecting dues, other than increasing the late fees, what else can smaller HOAs like us do, especially since we are not flush with money? And what's the maximum late fee allowed under Arizona state law? We have a homeowner that is consistently behind 2 to 4 months on their dues. Okay, so you don't have it quite right about, the associations not being able to charge homeowners legal fees. I guess automatically meaning you can't just charge it to their ledger, right? So let's just kind of back this up a little bit. Go check out our seminar that we did in July on, the changes in the new legislation that are going to be taking effect September 15th. So how do we handle owners post September 15th that are going to be delinquent in the payment of their assessments? You handle them just like we've handled them in the past, okay? You need to stay on top of owners who don't pay their assessments. You cannot let these debts get delinquent, by a lot of money. It's harder for me as your attorney to collect the debt if the owner owes, 4 years of assessments versus, 6 months. Easier to get them to write a smaller check. So under the new law, basically what we can do is we can lien for the lienable things that we're allowed to lien for. So for the unpaid assessments, we can't lien anymore for the attorney's fees. That doesn't mean we can't collect them. It just means we can't put a lien on their property for them. I don't know. I can't, I'm not a, future predictor, but I'm guessing that most attorneys, there's going to be a practice shift now. And we're going to have to change a little bit how we do things. And it's not bad. It's not good. It's just the reality of the situation. And so, my recommendation to you is, okay, if you have an owner that is consistently behind 2 or 4 months on their dues, here's my suggestion. Put a lien on their property. Send it to the attorney. Yes, the attorney is going to incur attorney's fees. The only way to collect those attorney's fees is to get a personal judgment against the owner. Go and do that, because that's the only way that you are going to get the attention of the owner, that if you don't pay your dues, we get a personal judgment against you. I think that is the best advice I can give you. That's the restrictions now under the law. What I would definitely not do would be, ignore the debts and just let them accumulate because, I think we're all sensing a shift in the economy that's coming here in the next year. And it's not going to be a good shift. So we're going to need to be ready as associations to combat owners that aren't paying their dues or their assessments so that we can meet our expenses as an association. Okay, question number 41, someone who's planning to be on the board. If a group of owners successfully submitted a petition to the board of directors asking to make 2 changes in the CC&Rs and bylaws, does this only need to become a motion before the board, read twice at meetings, and then voted yes or no, and possibly discounted by the board? Or since it was petitioned, would it be mandatory that we place the change request on the annual ballot for a community vote? Great question. Some association documents have a path for owners to ask for an amendment to the CC&Rs. Most don't. So I don't know, maybe your association has that in your documents. I'd have to check your documents if I saw it. Let's assume, because the majority of associations don't have this, let's assume that yours don't have that. And let's, consider what's going on here. So if a group of owners, and I don't know how large the group is, if it's 2 owners out of 100, that's not a very large percentage. If it's 40 owners out of 100, okay, now we've got a lot of people that are really concerned about this. I think the board should always listen to their owners, have a listening ear and listen to what they want. If it's something that is not acceptable to the board, respond back, invite them to the meeting or respond back in writing and let them know why. Talk about it with your attorney before you do that. If you have a large number of residents, like 40% of your residents wanting something, I think your board has an obligation to look into this and to possibly send it out for a vote. Okay, next question. Do you have to provide 48 hours notice of an executive session board meeting? We have a great cheat sheet on association board meetings that I'd like you to take a look at. The short answer on this is yes. Even though members cannot attend the executive session meeting, they still are required under the law to be notified of that meeting so they're aware it's happening. And don't forget, when you do that notice, make sure you list the statute and the statute number and the sections of the statute number that you're going to be discussing during executive session. Okay, question number 43 from a board member. We are self-managed, over 55, with 184 townhouse units. We have no website. Many members do not have email, and many others are part-time residents. Currently, we notice the meetings on a clipboard outside the entry to the clubhouse grounds that require you to walk up to the posting to read. What is the exact acceptable legal procedure to comply with the update of ARS 33-1804 to notice the board meeting and agenda 48 hours prior to any board meeting? So really, you can follow the same procedure that you have been following before. So put the notice on the clipboard, have a second clipboard with the agenda. That complies with the law. I would encourage you to diversify, though. I think 90% of associations, maybe higher, now have a website for their association, and it's just pretty much common, that's people have that now. And I think even though you may not have members right now who are demanding that, I think it would be good business practices to start implementing that so that your out of town residents would be able to know when the meetings are and potentially be able to zoom into the meetings if you have those meetings via Zoom. Okay, next question, number 44 from a board member. ARS 33-1810 seems to imply that an HOA annual audit, compilation review or audit, must be performed by a certified public accountant, since the descriptive terms, compilation review or audit, constitute report types that are only relevant to CPAs. Is this conclusion accurate? This is the tough question. Here's what the law says. Under 33-1810, and this applies to planned communities, we also have a similar sister section in the Condominium Act. It basically says, unless any provision in the planned community documents requires an annual audit by a certified public accountant, the board of directors shall provide for an annual financial audit review or compilation of the association. The audit review or compilation shall be completed no later than 180 days after the end of the association's fiscal year and shall be made available upon request to the members within 30 days after its completion. Okay, so the statute is very specific. So we don't really go by implications, as you indicated in your letter, that, this implies that the audit has to be performed by a CPA. It doesn't, specifically it says, unless your documents require an audit by a CPA, the board of directors can provide it. So my reading of that, and I think it's the correct reading, is that unless your documents say, hey, a CPA has to do this, the board can do it. And the board can delegate this to anybody they want. They could delegate it to a CPA. They could delegate it to a bookkeeper. They could delegate it to a financial committee. They could delegate it to some other independent, person that has some financial knowledge. I'm not saying this law is perfect. It's not, because if it's kind of a box checker, right? Because if your documents don't say you have to have a CPA, really anyone could do it. And that's kind of the fox guard in the henhouse, right? But that is what the law says. Now, I know that my CPA friends in the world, when I teach these classes, they go nuts when I say this, because they say the language of compilation, review, or audit, is generally acceptable accounting terms or something to that nature, and that it should be implied, but that's not what the statute says. So I have to go by what the statute says. Hope that answers your question. Question number 45. What are the key aspects for owners and the HOAs with respect to adding a tiny home at a single family residence? For example, does it need to meet design guidelines? We have a blog on ADUs that we're going to be, and casitas that we're going to be releasing early next week. So stay tuned on that. But the short answer is they just have to comply with whatever your architectural guidelines are for your association. Maybe your association doesn't allow guest houses. And in that case, that state law, doesn't change the fact that our restrictions that govern our property do not allow They do not allow ADUs or casitas. You have to go by what your CC&Rs say or your architectural guidelines. Okay, next question, number 46. Regarding amending CC&Rs, our revised documents require consent of 67% of owners to approve changes. Is there a minimum percentage required by law? And if so, what is it? So I don't know what your documents require. I have to look at, specifically look at your documents and see if you are a condominium or a planned community. Look at your documents first would be number one. So you're saying your documents require consent of 67% of the owners to approve the changes. Is there a minimum percentage required by law? If you're a condo, you can't go any lower than 67% by statute. If you're a planned community, you can go lower, but it's very rare that I see that under the law. Okay, question number 47. 18 months ago, we have accepted our last few parcels under development from the developer. There are some issues with drainage. I wasn't involved in those walks to accept them. I'm not the board president, and being called out by 2 new board members in open meetings as directing the developer to do the work is causing the issue. The developer admits to doing this on their own to solve the drainage problem. These 2 heard it directly from the person responsible. Would them still blaming me in open be considered slander? I mean, I don't have enough facts on the situation. It looks like you're a current board member. I think it's probably not appropriate that they were blaming you in open. Slander is hard to prove. There are many elements. It's expensive to win a slander case. So I think I would probably move on from this situation. I think maybe you want to talk about it with them, explain your position on it, and ask them if they would, in an open board meeting, apologize to you. These type of things get really expensive though. And I don't have enough facts here. I don't know how bad it was that they called you out and, this is affecting your livelihood, etc. So tough for me to answer it, but usually these slander and defamation cases are a nightmare to win and very, very expensive. Okay, question number 48. Our HOA is responsible for the landscaping and owns all the plants on every homeowner's lot. We are also responsible if the roots from the plants or trees cause a sewer issue. Since this can be costly, can we put a cap on the amount we pay for sewer repair? Also, if the interior of the house is taken apart due to the sewer repair and needs to be restored, is our HOA responsible for the cost of putting the bathroom back together? These are complicated situations when we have a sewer backup or a sewer line or sewer, pipeline that's going to the sewer that maybe falls and then causes a backup. It's also hard to determine, like, is it the tree root causing it? Is it a diaper that got flushed, or a wipe, a paper towel, whatever? So we really do need to look at this on a case-by-case basis. So, I don't think that you can put a cap on the amount you pay for sewer repair, because if you're responsible for this common area, apparently, and your tree is causing the damage, or the pipe separates, or, sinks and causes this damage, I've never seen that. And I don't think you can do that. If that separation or pipe causes some sort of damage to the unit or lot, usually the association is responsible if it's their fault for negligent or not. Usually, there is a cost to do that. Sometimes it's covered by insurance for the association, sometimes it's not. So when you're in this situation, you definitely want to reach out to our firm and we can help you navigate it. Okay, question 49 from a board member. We have several delinquent accounts and will be offering payment plans to some of our homeowners to allow them to catch up on their dues. Our CC&R states that we can charge interest at 7% for after 60 days delinquent back to their first time account was over 20 days late. This is the first time we are offering payment plans to delinquent residents. Can we add interest charges to our payment plans as per our CC&Rs? A couple thoughts. So don't forget, under the new law that's going into effect in mid-September, that every association has to have some sort of conciliatory language in their letters offering some sort of a payment plan for any amounts that are owed by the owner. And so good that you're ahead of the game on this and doing that already. If your CC&R say you can charge 7% per annum, you certainly have the legal right to do that. But what I'm going to tell you is it's a nightmare to collect that insurance, because you really have to know how to compute it. And oftentimes people are compounding interest. And when this gets to court, the judge gets very upset. So interest is kind of a nightmare for the associations to navigate. It probably would be smarter, in my opinion, just to charge the late fee, easier to compute, et cetera, especially when the payment plans are coming in and, the amount's changing every month. So the interest is, going to be changing every month. I think that's probably the easiest way to handle this. Okay, question 50. Do HOAs need to follow the Disabilities Act? We have a non-gated community, no clubhouse or pool. We want to add a sidewalk staircase down a hillside to shortcut a longer sidewalk, and some people are concerned about ADA compliance. I guess the question I have is your association a place of public accommodation? Like, typically, places of public accommodation would be like a public restaurant or a public, community building where anybody, not just owners or residents, can come in and use the facilities. I'm assuming it's not. Most HOAs are not a public place of public accommodation. So I'm more likely than not, you are not going to be subject to the Americans with Disabilities Act, but I'd have to check your documents to give you a more specific answer. Check out our cheat sheet on federal laws, because we give you a good definition of who's subject to the Americans with Disabilities Act and who's subject to the Fair Housing Act. Okay, next question from an owner. Does the board allow an adjoining homeowner to place a camera? Does the board allow an adjoining homeowner to place a camera and personal property on the benefit and use easement of the neighbor without the approval of the easement owner? According to the documents, notification is needed to access the easement and only for inspecting, maintaining, and repairing the party wall. This is an unusual one. So the board, it looks like we've got an owner asking this question. Does the board allow an adjoining owner to place a camera and personal property on the benefit and use easement of the neighbor without the approval of the easement owner? I don't think they should be doing that, frankly. Because it says under your documents it's only for inspecting, maintaining, and repairing the party wall. It doesn't talk anything about, putting in cameras or personal property. So I think that I would shy away from doing that or allowing that. Okay, that was our last question. We had a very busy morning this morning with 51 questions. I just want to make you aware that class number 8 of the 2024 Virtual HOA Academy will take place on Tuesday, August 20th at 11 a.m. Our topic is our community associations. We're going to define planned communities. What are their responsibilities and roles? And what are some secrets of successful associations? How can you get your board and your association to have successful outcomes? We're also going to talk a little bit about the new legislation that will be going into effect in 3 weeks after August 20th. So we'll spend some time on that, answer any last minute questions you have on that. We're going to talk a little bit about how to define HOAs, the governing organizational structure in an association, rights and responsibilities of the board and of homeowners. Also, we're going to give you some tips on how to be effective in running your association. So thank you so much for being here with us today. One parting that I have for you is if you would be so inclined, we would certainly appreciate it if you would consider leaving our firm a review on Google and or on Yelp. We really appreciate receiving feedback on how you are liking First Fridays. Is it helpful? Is there a different format that you'd like? That's really the only direct feedback that I can get from you. And so I would really appreciate receiving a review. We are sharing a link in the chat on how to leave a review. And we are always happy to get feedback from all of you on how we can do better and provide more free education for you to help you be better board members, community members, and managers.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.